to go. The owner at that time was in Cape Town and would return on the Monday. Accused 2 needed doctor to explain and or produce the bag. During the conversation, accused 2 asked Paul to help him. Paul knew someone, namely Peter. Peter, Paul, and accused 2 met. 2 explained the problem to Peter. Paul could not have known the detail unless he had been told it by accused 2. Paul also knows detail unknown to Peter and which could not have been manufactured. I've set out the portion of Paul's evidence which was not known or spoken to by Peter. The balance of Paul's evidence corroborates in the material respects the evidence of Peter. The accused. The evidence of each of the accused was a denial. Accused 1 admitted he frequented Money Point but claimed that he had been present about his own affairs and that he was not a participant in these events at all. He knew of Colonel Klimber as he had spoken to him about his apparent blackmailing of a friend of his. It is probable, in my view, that accused 1 was not just lounging about Money Point as his evidence would have it. It is much more probable that Money Point was as described by the witnesses, namely the hub of a business accused 1 was controlling. Every activity undertaken involved as a material part of it some incident at Money Point. Lukele was taken there, discussions were held there, the search was coordinated from there, attempts were made to get doctor to go there. Accused 1 on the state's evidence was alerted to and in control of the plan to export the drug, the plan to kidnap Lukele, and the implementing of the plan. Accused 2 denied participation in any drug deal, kidnapping or assault. He admitted that he was urgently seeking doctor at the time. He gave as a reason that he advanced doctor money which was to be repaid. The money had been advanced to enable doctor to purchase clothing which he would sell in a business. He stated that he stopped looking for doctor as, at a point in time, he had been forced to pay at least some of the debt due to the person from whom he had borrowed the money, and that for that reason he had ceased looking for doctor. This explanation is highly improbable. As I previously said, the moment a creditor pays over his own money because the debtor failed to pay him is the moment when it becomes even more important than before to obtain payment from the debtor. The much more probable reason to stop the hunt would be the realization that the subject matter of the search, namely doctor in the bag, could not be found. Accused 2's evidence as to what he was to be repaid is also improbable. At a point in time, accused 2 claimed that he was to be repaid a certain amount. Subsequently, he claimed he was to be paid that amount and a share in the business. He also claimed that the full amount was fully due, owing and payable at that point in time. This could not be unless all the clothes which had been bought with the money had been sold. It is improbable that this could have happened as a unit. It is much more likely a business over the period of time would generate funding, and that as and when it did, the debtor would pay the creditor. At a point in time, accused 2 seems to indicate that the urgency was related to the salary doctor would receive at or about that time. This suggestion is highly improbable, having regard to the small salary and the large amount accused 2 was seeking to recover. The claim of 2 is in direct conflict with the evidence of the state witnesses. It is improbable, having regard to the scope of the search, the number of people employed in it, the amount of money changing hands, and the urgency. It appears to me that accused 2's evidence is false. The search concerned attempting to recover drugs and the missing courier. The search included the kidnapping and assault of Lukele. There is no explanation on the evidence for accused number 2 for the kidnapping and assault on Lukele. The probable reason for the kidnapping and assault is, as set out before, to flush out doctor and recover the drugs. Accused 3 is a member of the South African Police. On the 25th June 2013, he had 3 phones which he kept with him continuously day and night. He was investigating and was on duty. He used a Mazda 6, a police vehicle allocated to him. He was investigating corruption of traffic officers on the East Rand. On that day, he was nowhere close to Katlehong, which is the place where Lukele was kidnapped. He was nowhere near the Cecil garage at or about the time the meeting took place prior to the kidnapping. He denied being at any of the other places. He was involved in none of the offences, according to him. He knew about a bag of drugs in the abstract as he had heard about it. He had no personal knowledge of these things. Accused 4 and 6 are his colleagues. He knew neither accused 1, nor 2, nor 5. In 2013, Krejcir had asked him to set up a meeting with 1 and asked him if he knew accused 1. He did not set up the meeting as he did not know him. He later said in conflict with his earlier evidence that Krejcir had phoned him and asked only if he knew 1. He had not asked him to set a meeting. He knew Peter. They had from time to time lent each other money. On the afternoon, 25 June 2013, he was at Bradford Road and at or near Money Point. The records show the vehicle parked near Bradford Road and stationary there for a period of time, moving a short distance and stationary again. Accused 3 said he was not inside Money Point. He was at the taxi rank about 100 meters from Money Point. He said that he'd worked together with accused 4 in the same group and that their vehicle records would show them together at OR Tambo at the airport. At that time, they were working on a complaint involving rifles, RDP houses, and drugs. He previously had said that the work with which he was involved was corrupt traffic officials. During the course of the trial, it was put by accused 3 that the vehicle he drove was allocated to him for his exclusive use. When he gave evidence, accused 3 modified the version to cope with the conflict in his evidence that he did not have exclusive use of the vehicle by saying that the person with whom he shared had come after the vehicle had originally been allocated to him exclusively. This point might appear insignificant, but it is material as the sole use of the vehicle founds his alibi defense. Accused 3 referred to vehicle records as establishing he was not at Lekele's home at the time of the kidnapping. The records show the vehicle in which he claimed to be, inter alia circling in the immediate vicinity of the airport and at a time stopping near accused 4's vehicle. The evidence of accused 3 is flawed in material respects concerning inter alia his exclusive use of the motor car, why he was with accused 4 on the day, and in particular what he was doing in the afternoon he was at or near Money Point. The probabilities are that the vehicle used by 3 would not drive aimlessly around the airport as it seems to have done. The investigation, whether it involved traffic officers, rifles, RDP houses, and other corruption, including drugs, remain unlinked to the movement of the vehicles and the movement of 3 on the day. It appears to me that 3 and 4 have orchestrated an alibi through the use of their vehicle records. The value of the vehicle records would be well known to both the accused 3 and 4 to establish their whereabouts. The fact that any particular cell phone records demonstrate accused 3 as being at any particular place on any particular day do not independently of his evidence establish his whereabouts. He had a number of phones, shared the vehicle, and in my view has no cogent explanation for the manner in which the vehicle was driven at the relevant time. In addition, accused 3 was identified as being at the garage at the Cecil garage at Money Point when Lekele was assaulted, at Bethel at the filling station, and at Ermelo when they were looking for Doctor by Peter. Paul identified accused 3 as being at Money Point when Lekele was assaulted and at Ermelo when they were looking for Doctor. Accused 3 himself put himself at or near Money Point in the afternoon at or about the time of the kidnapping. The coordinates show, according to what was put to him, that he was on the premises. These records are apparently accurate according to the expert to within 5 meters. He was also seen at Money Point and admittedly went there. He claims he went on business. In my view, it is not a coincidence that accused 3 is linked to events at Money Point by the witnesses, and his admission that he was there on occasion, but for a different reason in my view. Accused 4. The evidence of accused 4 was that over the period of the kidnapping he was working with the organised crime unit, and in particular that on the 25th June 2013 he was working with 3 on the same project. He was involved in the observation concerning a crime involving drugs. He said he was working with 3 but was not with him continuously. He specialized only in drugs. That was his main concern, whereas 3 was a coordinator of the other matters which were being investigated. This is in conflict with his evidence given at a point in time that 3 and 4 were working together on a number of matters. Accused 3 did not isolate any particular matter as being within the domain of 4. He explained he was at OR Tambo on 25 June 2013 for observation. He also had his own purpose, which was to fetch a plane ticket for his child who was leaving the next day for Durban. Subsequently, it became clear that he was fetching not only a ticket for his son but for other people. There was also confusion in his evidence relating to when he was supposed to travel and when precisely the travel would take place in relation to the fetching of the ticket. He was unable to explain why details which had been given by the state witnesses, such as that he was a policeman, had worked with accused 4, had been at Money Point at or about the time when his records show him to be there. In addition, accused 4 put it to Captain Ramahala that the reason 4 had been to the airport was to purchase a ticket, as if that was the only reason to go there. It was not put that he was there about the business together, or there about police business together with 3. I do not accept the evidence of 4 and do not accept that he was in exclusive possession of the vehicle or in possession of it at all at the time that he was identified as being one of the kidnappers at Lekele's house. I further do not accept that he was not present in Ermelo. It was submitted there could have been an error made by Lekele in identifying accused 4, whose name is Jeff, in that Jeff was the person who had been at the property earlier in the day, bracket, Peter, close bracket, and was not the current accused 4, Jeff. There is no evidence that the witness was in any way confronted with the names of the persons he identified, or that he identified any person on the basis of a name. He identified on the basis of what he saw. He dealt with the 6 attackers at his home for some time. He was in their presence for some time prior to being manhandled and bundled into the car. In the later statement he made, he said he would be able to identify them, although he did not give a description. The fact that he did not give a description is indicative of poor police investigation rather than his inability to give one. In an affidavit dated November 2013, Lekele said that his eyes were closed so he might not be able to identify his attackers. This is the only very hesitant indication that he could not identify them, and is directly in conflict with his earlier statements that he was able to, and his subsequent conduct in actually identifying them. Accused 4 produced documentation reflecting he had been in possession of the motor vehicle issued to him by SAPS. This was presented as an alibi based on a finding that he was in fact in possession of car and cell phone. They were similar in nature to those produced by 3. For quite some time over the relevant period, the 2 accused were driving seemingly aimlessly around the airport. Both accused at all times are aware of the tracking capabilities of cell phones and of the cars which they drive, which are fitted with extremely accurate tracking devices. It is inconceivable that they would take those cars with them when they wanted to perform activities where they did not wish to leave an electronic trail. It is much more likely they would use them to create a fictitious alibi. I do not accept accused 4's version. Accused 5's evidence was a blunt denial of what had been said of him by the state witnesses. He said his name was Mia and that he had never been known as Zulu Boy or Spoo. He raised as an issue that he may have been implicated because he had fallen out with one Klimba. It is apparent from the facts which I've set out previously that he was identified positively as being a participant in numerous of the events and by numerous witnesses. His explanation is not only incredible, it appears to me to be untrue. There is simply no indication of any accused being substituted for any participant. The detail concerning his identification is detailed in time, place, and event. He is a person involved in the taxi industry in which people are killed for little money. He claimed never to have experienced this. It is a well-known feature of this country that the taxi industry is regularly involved in violence. The motive of Peter and Paul to implicate him appears to me to be non-existent. Peter identified accused 5 at Money Point, where Lukele was assaulted at the safe house on 25 June 2013, as being with him hunting in Davidton, as being with him at Money Point prior to the Ermelo Point, and at Money Point when they returned. Peter also identified him as being the person who took Lukele to phone Doctor, and as the person who spoke to Doctor. This evidence is corroborated by a doctor. He was also one of the people who was opposed to the killing of Lukele. Paul identified accused 5 at Money Point prior to the Ermelo trip. Accused 5 fetched Lukele from the safe house. During the Ermelo trip, he was identified as the person who paid for the petrol and the snacks with the money he got from accused 1. Paul well knew accused 5. Accused 6. Accused 6 is a member of the South African police. Similarly, his evidence was a blunt denial. He conceded that he works together with accused 3 and 4 at the same office. At the time of the events, he was on leave. Accused 6 was similarly identified as previously set out by numerous witnesses whose evidence was reliable. He was identified as being at Money Point when Lukele was assaulted and at the Bethel filling station on the way to Ermelo. Paul identified 6 as being at Money Point before they left on the Ermelo trip and also at Ermelo. All the accused were identified at various points in the events by various witnesses. All save for accused 4 were present at Lukele's assault at Money Point. One or more, all of the accused were present at various other points. The witnesses who gave evidence of the trip to Ermelo identified which accused was present at which particular time. There is evidence which inherently contains the assertion that those who had left for Ermelo returned. The fact that different witnesses saw different accused at different times does not mean they were not participants throughout the Ermelo incident. The witnesses who gave evidence of occurrences where only a few of the accused were present corroborated each other as to what had happened. All the events spanned more than a few minutes each. There was ample opportunity to observe in each case. The sightings occurred over several days, and the witnesses had both time and opportunity to recollect and reinforce the identification of each of the accused. In addition, certain of the accused were well known to certain of the witnesses. In my view, the identification of each of the accused is reliable and supported by the probabilities. The identification of ice, tick, crystal meth as methamphetamine. Count 1 charges the 6 accused with dealing in an undesirable dependence-producing substance in breach of Section 5B of Act 140 of 1992, in that the accused dealt in methamphetamine, commonly referred to as crystal meth stroke ice stroke tick. It is an element of the charge, and the state is required to establish that the accused dealt in 25 plastic bags containing that substance. The first issue is to be resolved to be resolved is whether the state established that the substance allegedly dealt in was the substance defined in the act, namely methamphetamine. No expert evidence was called. The evidence was that accused 2 referred to the contents of the bag as being drugs. Paul told Peter, in the presence of 2, that 2 had also told him that what had been lost was 25 kilograms of crystal meth. Accused 2 agreed to pay Peter 2 kilograms of tick if the bag containing all the drugs was recovered. Paul said that accused 2 had said that he had a problem about a bag containing ice, which was supposed to be sent to Australia. Accused 2 is the source of the information of what the bag contained. He knew what was inside it. Doctor referred to the substance as ice. Doctor did not know what was in the bag, which was sent on the dummy run, but was told by accused 2 that it was a drug. Accused 2 gave Doctor the bag containing the 25 parcels. Doctor thought that the contents were ice, as in frozen water, as when he was told to take the bag with him, his response was, "What if it melts while in my possession?" Doctor's description of the contents of the parcels as having properties similar to the properties of ice is indicative of the fact that he was told that in fact they contained ice. He, Doctor, clearly had no idea of what ice was and assumed the reference to be frozen water. The fact that this suggestion to him led him to believe that the properties of the packets were frozen water is indicative of the power of the suggestion which had been made to him. In my view, the state proved that it was stated that accused 2 on various occasions stated that the parcels contained crystal meth, tick, and ice. Additional evidence that the bag in fact contained drugs is found in the elaborate and furtive process to export the bag, the value of its contents, and in the nature and the cost of the search to recover the bag when it was lost. This was a hunt on a large scale, a hunt at all costs to recover something extremely valuable. The statement of accused 2 is not admissible against the other accused, but is one of the facts setting the matrix, and what he stated is obviously admissible against him. In my view, the bag was proven beyond reasonable doubt to contain a drug known as crystal meth, tick, and ice. The question remains whether that evidence establishes that its contents were methamphetamine. I consulted a number of online dictionaries, including the Oxford Dictionaries Online and the Concise Oxford Dictionary. The Concise Oxford Dictionary, 10th edition, published 2001, defines meth, brackets, also crystal meth, close bracket, as being methamphetamine. The Oxford Dictionaries Online describes crystal meth as being methamphetamine. The Memedic's Online Dictionary describes crystal meth as a methamphetamine derivative used in the form of a crystalline hydrochloride. Its source is given as a crystal methamphetamine or methamphetamine hydrochloride. The synonyms for the substance include crystal, glass, ice, and meth. The Memedic's Dictionary, which defines crystal meth as being crystal methamphetamine, describes it as a concentrated and highly potent form of methamphetamine with dangerous side effects. A number of other dictionaries, which are referred to online, describe methamphetamine, ice, tick, crystal meth, crystal, all as synonyms for methamphetamine. In my view, the English language defines the name of all the references, namely crystal meth, tick, or ice, as meaning methamphetamine. The use of the language by accused 2, being the colloquial usage of methamphetamine, constitutes an admission by him and a reference by him to the prohibited drug methamphetamine. In the present matter, the drug forming the subject matter of the charge was sold by doctor and is irrecoverable. It is impossible to check and analyze the substance contained within the plastic bags. The only source of the contents of the bags can be the ipse dixit of two to the various slang usages meaning methamphetamine. The use of the language by two of the abbreviation and slang having the same meaning as the word contained within the statute is, in my view, a reference to the word contained within the statute and the substance defined by that word, namely the prohibited substance. Accordingly, accused 2 on the evidence provided Accordingly, as far as accused 2 is concerned, on the evidence provided, knew and described the contents of the bag as being methamphetamine, the illegal drug which I found the contents of the bag to be. Each of the 25 bags was worth approximately Rand 300,000, and the total consignment was worth of the order of Rand 7.5 million on the evidence before me. The extent of the steps taken to recover the drugs demonstrates the employment of a significant number of people and a significant degree of urgency. These steps must have been expensive. Peter would have been paid of the order of Rand 600,000 had the drug been recovered. The lengths to which the persons seeking to recover the drug were prepared to go also indicates the value of the substance and that it is a drug. It is highly improbable that for a relatively insignificant amount, Lekele would have been captured, tortured, and held hostage for several days. In addition, the resources which were employed in the attempts to recover the bag, there was also expenses which were incurred. For example, traveling to Ermelo, hiring the various policemen who participated in the hunt, traveling to the airport, to Katlehong, and the various other places which almost on a continuous basis, which almost on a continuous period over some days was undertaken by a significant number of people, including in particular accused 2. In my view, it is established beyond doubt that the bag contained methamphetamine. Section 256 of the Criminal Procedure Act makes it competent if the evidence proves an attempt to convict of an attempt. Section 256 provides, if the evidence in criminal proceedings does not prove the commission of the offence charged, but proves an attempt to commit the offence, or an attempt to commit any other offence of which an accused may be convicted on the offence charge, the accused may be found guilty of an attempt to commit that offence, or as the case may be, such other offence. This section makes it competent for an accused who participates in a crime to be convicted of an attempt if the facts are appropriately proven. The offence charged is dealing in a prohibited substance. The offence charged An element of the offence involves not just the existence of a state of affairs, but proof that the affairs concern the prohibited substance. The definition section of the Act provides that dealing is constituted by performing any act in connection with the transshipment, importation, cultivation, collection, manufacture, supply, prescription, administration, sale, transmission, or exportation of the drug. And the offence which is contained in Section 5b provides that no person shall deal in any dependence-producing substance. In this case, accused 2 and accused 1 were involved with the arrangements for an exportation of the drugs contained in the bag. Accused 2 was the person who made arrangements with the courier and who implemented the plan. Accused 1, beyond doubt, is the mastermind who only appears as and when required. Accused 1 was intimately involved and in control of all the events described by the state witnesses. Accused 1 and 2 were also instrumental in attempting to recover the bag by way of recovery of the person in whose possession they had left the bag. The knowledge of accused 2 was the knowledge of accused 1. Accused 2 and accused 1 both knew that drugs were inside the bag. Accused 2 knew the drugs were methamphetamine. Accused 1, according to what accused 2 said, would also have known this. The extracurrial statements of accused 2 concerning the identification of the drug as crystal meth, tick or ice are inadmissible, however, against accused 1. Accused 1's knowledge is limited on the admissible evidence before me only to the fact that the bags contained a prohibited drug. In my view, the knowledge of accused 1 extended to any one of the prohibited drugs listed in the Act, and in fact any one of the drugs listed in the Act. Hence, accused 1 attempted to deal in methamphetamine as the state proved that what was in the bag was in fact methamphetamine. What the state failed to prove as against accused 1 was his knowledge as to the contents of the bag. The provisions of Section 256 allow a conviction of an attempt. In State v. St. Law 1982, 2 SA 202, Nestat J. held at 205 that a conviction of attempt was competent on a similar provision. In the present case, accused 1 was attempting to commit what on the evidence before me is impossible, namely the export and recovery of a prohibited substance which has not been proven as against him to be the particular one alleged. Hence, on my analysis, accused 2 is guilty of count 1, while accused 1 is guilty only of an attempt to commit the offence in count 1. Accused 3, 4, 5, 6 and count 1. It remains to deal with the involvement of accused 3, 4, 5 and 6. It was submitted that the evidence did not establish beyond reasonable doubt that they knew the person they were hunting was being hunted because of his possession of the bag of drugs. The bag and doctor were freely discussed among all the accused. There is, save in respect of accused 5, no evidence actually identifying the contents to the accused. In respect of 3, 4 and 6, there is no reliable evidence they knew the bag contained drugs. The position of 5 is different. At the meeting where the killing of Lekele was discussed, accused 5 and others opposed his murder. At that time, accused 5 said they should not kill him and that they were seeking drugs worth millions. Hence, he knew the bag contained drugs. There is no evidence that he knew which specific drug was within the bag. However, on the same reasoning as applicable to accused 1, he is guilty of an attempt. Identity generally. The witnesses who identified the accused were able to, in addition to making the identification, correctly refer to numerous facts about each witness. The witnesses were able to identify the policeman as such, money point as the hub of activity, the different roles each accused played, features of each individual accused, and so on. The fact that the corroboration in detail exists strengthens the probabilities that the identification is accurate. On the aforegoing analysis, it appears to me accordingly that insofar as count 1 is concerned, accused 2 is guilty on the main count, while accused 1 and 5 are guilty only of an attempt. In respect of count 2, it was established in respect of all the accused they participated from time to time. On count 3, there was evidence in relation to accused 1, 2, 3, 5 and 6, but not accused 4. In my view, the evidence given by the accused is not reasonably possibly true and cannot be so in the light of findings which I've made with regard to facts which underpin whether or not the evidence can be reasonably possibly true. The SAPS. The accused submitted that Lekele had made a conscious decision not to pursue any charge. and hence the earlier charge had not been prosecuted. These submissions arose out of the fact that a docket had been opened pursuant to a charge being laid by Noble at the time prior to the release of Lukele. The police, according to the investigation diary, had taken steps to investigate the matter, concluding that the registration number given by Noble and the type of vehicle were incorrect. On 3rd July 2013, the police discovered that Lukele was at home having been released. Lukele told him, according to the docket, that he had been released because persons who had kidnapped him were looking for his brother, not him. There is an entry contained within the docket dated 8th July 2013 stating that the docket was closed as being false. Notwithstanding the clear evidence before the SAPS as to the facts concerning the kidnapping of Lukele, no further steps were taken by them. The next step in the investigation was the assignment of the case to the investigating officer, Captain Ramahala, by General Munu. The instruction Captain Ramahala received was to trace and arrest the suspects. At a point in time, he received the old docket from General Munu. This docket appears to have been made available at some time after the investigating officer had commenced the investigation. It is apparent that the investigation was commenced not in consequence of any initiation of it by Lukele, but from some other source. It became common cause that the fresh investigation had commenced on the instruction or emanated from the National Task Team in Pretoria. It appears as if the police had discovered the existence of what had happened to Lukele and, pursuant to an instruction to investigate further, did so. It was submitted that the instruction given was to get accused one, and that in the course of doing so the police behaved improperly in the investigation by creating and or tampering with and or failing to obtain evidence. There is no evidence that the police in any way were instructed to falsely implicate any of the accused, or that the police in fact did so. There is no evidence of any conspiracy on the part of the police to implicate any of the accused or modify the evidence. The evidence of the kidnapping, assault and drug deal are established independently by the witness to the events. Accused 1 and 2 have been found by me to be party to those events independently of any police action. The other accused, 3, 4, 5 and 6, are identified by detailed evidence corroborated in material respects. In my view, not only is there no evidence of tampering, it is improbable that there was tampering with the evidence. The investigation of the police was poor. There were sources of information which could have been collected and used. There were leads which were not followed, and there was objective evidence which was not obtained. The fact that the investigation was poor and some evidence not obtained in no way leads to the inference being capable of being drawn that the evidence was in any way tampered with, or that in any way any of the witnesses were directed as to who should be implicated. The submission is made that as the police knew who the suspects were, the identity of the suspects could have been created by the police with a view to them being implicated. There is simply no evidence of this conduct. The submission was made that there were, throughout the occurrence of the events during June 2013, numerous phone calls made to and from several witnesses and one Colonel Klimba. The cell phone records of the various witnesses evidence frequent phone calls being made from time to time over the period. The explanation of the witnesses was that the phone calls were innocently made and had nothing to do with the case. Even assuming the phone calls were related to the case, the fact that they were being made in no way means that the facts were being invented or manipulated, or that the accused were being substituted for perpetrators. One does not know if Klimba, in the course of his involvement by way of phone, was evidence gathering for the SAPS or whether he was a rogue operative. Whichever one of the two it was does not have any effect upon the facts before me, and his conduct, in my view, on the evidence before me does not amount to any change or tampering with the evidence placed before me by the witnesses. The rhetorical question was put to me as to how the police could know that persons not identified in affidavits were the physical persons who subsequently became the accused. The answer of the investigating officer is that there were informers and that the witnesses were reliable. Before me, the witnesses gave evidence, and in my view, that comment made by the investigating officer as to the reliability is accurate. The submission was made that the trial was unfair in that evidence which had not been collected, in that certain evidence had not been collected, and, for example, an identity parade had not been held. The submission was made that had an identity parade been held, the accused would have been vindicated, as witnesses would not have identified them. Had video recordings which could have been collected, the accused would have been vindicated, as their presence would not be visible on the video. In my view, these are all highly speculative submissions founded upon the premise that the accused were not participants. All of the witnesses who gave evidence as to the identity of the accused, in my view, attempted of their own accord to describe and relate how each particular accused was involved and why that accused was involved. It was submitted that certain of the evidence was taken unconstitutionally, in that, for example, a witness had been lied to as to the reason why he was being taken to the police station. The answer to this is that there may well have been lies about why the witness was being taken to the police station. However, the witness voluntarily made a statement there and subsequently voluntarily testified. In my view, the concept of fairness in a trial was in no way eroded in this case before me. It was submitted that several of the records establishing the whereabouts of the cell phone of the investigating officer and others demonstrated that what had been said in evidence was inaccurate. The criticism is factually correct. It must be remembered that the kidnapping endured over a period of time. The events took place over an extended period of time. In addition, the persons hunting the accused and the bag of drugs were under pressure to perform the hunt. They appeared to me to have done a large number of things in a short space of time. In these circumstances, it is not unreasonable for a witness to remember certain events in an inaccurate order or in a slightly inaccurate way. The question is not whether there is an inaccuracy. The question is whether or not the reliability of the evidence remains intact, notwithstanding the inaccuracy. In my view, the witnesses who gave evidence before me attempted as best they could to give detailed evidence over an extended relating to events which took place over an extended period of time, and accurately and materially described those events. One would expect witnesses dealing with extensive facts and over an extensive period of time to inaccurately recall minor details or to jumble the order on occasion. In my view, the true result of the police's improper and inadequate investigation, for so it was in this case, is that it put the state case at risk. The state case was dependent upon an unlawfully obtained confession which I excluded in evidence, and such witnesses as the state was able to marshal. By the nature of the events, many of those witnesses fall into the category of accomplice. I'm conscious of the fact that accomplice evidence can be and often is easily manipulated. An accomplice can easily substitute one person for another while maintaining the true set of facts. The accomplices in this case are accomplices in respect of different facets of the case which overlap to an extent. Some were hunters, some were drug dealers. There is sufficiently objectively accurate evidence and factually corroborated evidence for their evidence to be accepted, notwithstanding their particular relationship to the persons involved. The overlapping portions of the case are insightful, as the different witnesses to different events would not in detail, as they did, give the same evidence unless it was true. I've not dealt with each of the submissions made and each factual discrepancy allegedly existing, as those submissions ran into hundreds of pages. I've dealt with what I believe to be the pertinent issues and the probabilities, namely what happened, who probably caused what happened to happen. Those inquiries, which I believe to be the proper ones, encompass a relatively small portion of voluminous evidence and extensive cross-examination into minutiae. I allowed extensive cross-examination, although I at the time believed that the cross-examiner was merely milling grains of sand on the beach. After the milling of all these grains of sand, the picture of a beach remained the same. It was still sand on the beach. The accused, however, was allowed fully to exercise all of their rights of obtaining documents and investigating each aspect as deeply as the laws of evidence permitted. The fact that after this intensive attack upon the witnesses' evidence, the witnesses remained intact is testimony to the fact that they were telling the truth. I refused an application for the discharge of the accused. I said I would give the reasons later. The reasons which I've set out above are those reasons. It follows that, in my view, as far as count 1 is concerned, accused 2 should be found guilty of the main count, accused 1 and 5 guilty of an attempt. In respect of count 2, in my view, all the accused before me should be found guilty, and in respect of count 3, accused 1, 2, 3, 5 and 6 guilty. It remains only to deal with the Section 204 witnesses. The witnesses who were warned in terms of Section 204 gave their evidence acceptably and are entitled to the indemnity the section permits me to give them. It is a matter of sorrow that persons who were involved in reprehensible conduct walk free. The law recognizes, however, that society must sometimes sacrifice its right to convict wrongdoers in the interest of convicting others. There was no easy way for the state to obtain a conviction otherwise by using witnesses who were complicit in the events. It is apparent from what I have said, and it is my view, that the following is an appropriate order, and I convict the accused as follows. 1. Count 1. Accused 2 guilty, main count. Accused 1 and 5 guilty of attempted contravention of main count. Accused 3, 4 and 6 acquitted, main count. 2. Count 2. Accused 1, 2, 3, 4, 5 and 6 guilty. 3. Count 3. Accused 1, 2, 3, 5 and 6 guilty. Accused 4 guilty of common assault. 4. Section 204 witnesses. 4.1. The witnesses mentioned below are indemnified from any possible prosecution arising out of the events specified. 4.1.1. Peter Vusi Msimang is indemnified from any possible prosecution in relation to counts 1 and 2 of the indictment. 4.1.2. Paul Mtabela is indemnified from any possible prosecution in relation to counts 1 and 2 of the indictment. 4.1.3. Becky Sizwe and Dr. Nkosi is indemnified from any possible prosecution in relation to count 1 of the indictment. 4.1.4. Becky Zita Sobaba Kumalo is indemnified from any possible prosecution in relation to count 1 of the indictment. Court adjourns.
Bail is still extended. Number 3.
So evidently tell me, all these guys now the break is extended for this one.
I don't know why he's doing. He told me if they ask, I must tell them tomorrow.
Oh, so we're coming back tomorrow. Okay, thanks, Avidia.
But now nobody's actually asked me apart from Mr. Substantiation.
Yes.
So I don't know.